A firefighter in West Virginia, whilst carrying a 40-pound tote of laundry up a flight of stairs, felt a pop in his knee. He eventually ended up filing a workers' comp claim in West Virginia. It went all the way up through the Court of Appeals process, and eventually they found that it was a compensable claim because he was doing something which was it was a peculiar risk of employment, as how they stated it, distinguishing it from a neutral risk, i.e. he wasn't just descending or ascending a flight of stairs without any, whilst not carrying items. He wasn't simply walking across the floor. So he was carrying this 40-pound tote of laundry, presumably it's to clothes related to his firefighting duties. And so they allowed the claim. And so the question is, so that's West Virginia. We're in Ohio. Would they allow this claim in Ohio? And the analysis in Ohio is fairly probably similar, but that neutral risk kind of aspect of this analysis, they consider there's a defense that doesn't exist in Ohio yet, and hopefully it doesn't, but it's called coincidental to employment. And the idea is, again, this is a defense that doesn't exist, but the idea is you're doing something not related to your work and you suffer a work injury. And so the cases, some of the cases are a little bit attenuated, but there's like somebody getting off, they're stepping off of a trash can, or they're descending down to sit in a chair and they feel an injury in their knee. And so, but where the analysis would start would be, did the injury occur in the course of employment? And that considers the time, place, and circumstances surrounding the injury, and then the arising out of employment. So it has to be in the course of and arising out of, and they're similar, but the arising out of considers I call the PCB, the proximity, control, and benefit. Proximity of the injury, of the proximity of the workplace to where the injury occurs, benefit the employer for where the employee is, where the injury occurs, and the control over the place where the injury occurs. And so if you had a firefighter working in a firehouse, would be in the course of employment. Well, I would say it was, if he's schlepping the tote of laundry up for the purposes of cleaning it, it's like firefighter clothing, then I would say the course of applies. And then the arising out of, the proximity, control, benefit. I mean, it's in the fire department house. The fire department has control of the staircase, and it benefits the fire department to have clean clothes or whatever the guy is cleaning. So it's allowed in West Virginia, this situation, and I argue it would be allowed in Ohio as well.